Jeremy Saland, former assistant district attorney for the Manhattan DA's office, and former federal prosecutor Gene Rossi. I'm going to start with you, Jeremy. We just heard some of the defense there that this is not common. How common is it for someone to be charged with this kind of a gun charge in this case?
Well, when you look at the statistics, there's plenty of thousands of people get charged for these gun-related crimes, but the particular offense for which he is charged is generally not charged, certainly on an island, meaning by itself as its only offense. And when you look at the circumstances as well, where no one's accusing him of shooting somebody else or being a kingpin in some unrelated drug transaction, this is a 5-year-old offense or so, where he had the firearm for roughly 11 days and simply filled out some paperwork. So it is atypical as an island by itself, but even generally, you don't see it that common with other crimes.
You're saying if there wasn't other crimes committed with that firearm, it is not likely that they would put this particular charge out there
and
by
the statistics bear that out.
Okay.
Gene, if I can ask you, this hearing is before a magistrate judge today for Hunter Biden, but the judge presiding over this case is the same one for whom the whole case, the plea deal, fell apart beforehand. Is there any chance that that judge could say, you know what, you two sides go work this out again, get back there and figure out something else, because this particular gun charge, as Jeremy was just saying there, is not something we normally see by itself?
No, a magistrate judge will not do that, because
not
that
the magistrate judge. When it goes to the next phase after today. Today is procedural. Today is in and out. They're done. They move on. But when the presiding judge starts to weigh in on this again soon.
Yeah, I misheard you, John. I apologize. No, the district court judge would not do that, because you're putting your fingers in the pot. They have to stay a little bit removed and let the parties negotiate, if possible, before trial. I do have to make one comment. I have a client down in Newport News, Virginia, 25 years old, high school dropout. She has been charged and pleaded guilty to a G3, the user charge. I will say this. If it were Hunter Smith and not Hunter Biden, he would not be charged with this G3. John, I was on your show a couple weeks ago, and I talked about one of my defendants who had a very evocative nickname. And in a case where there's violence, you would charge this user charge. But in this case, the standalone, it is never done in my almost 30 years as a federal prosecutor.
Jeremy, the special counsel is still investigating, which obviously leaves open the possibility that no matter how shaky the ground is that these charges are on, or how if on an island he would really not be charged, whatever it is, we are where we are today. The tax crimes that they're still investigating, how likely is that to pile on now?
I certainly think that's a possibility. They're investigating it now still. Yeah. But even again, I don't want to make something smaller than it is, but at the same time, we don't want to make it larger than it is. This is not the most grave tax crime either in terms of the dollar amount that we're discussing.
So what does that mean then about the penalty, the consequence that he could pay here?
Well, I think you can see from what was initially offered, even though it fell through, this is not an incarceration issue. Certainly things can change, one never knows, and a judge can make a decision, but on its face and based on the history of the case, I don't think that's the issue here. And I would just add, to take a step back, a controlled substance is marijuana with the federal government, even though some states legalize marijuana. So theoretically, if you're smoking marijuana or denying that you're smoking marijuana and getting a firearm and abiding by the laws of your state, such as in Missouri, for example, and getting that firearm, you're running afoul of this law. It just seems very silly, and that's not a legal term, but it seems very silly that we're here for this type of offense.
It should be a legal term, though. I think it should.
Well, if you use it in quotes, it might be.
Everything works in quotes.
I want to move to the other case that we are watching right now, which is Donald Trump's fraud case here in New York. Trump has said a couple of things, and I wanted to get your take on this. He thinks that it's unfair that he doesn't have a jury. He has said that. And he says that the fraud case is election interference because he has to be in court and cannot be out on the campaign trail. Doesn't he have control of those two things?
Nonsense and nonsense. If he wanted a jury, he could have asked for a jury. There is nothing that precludes him as a matter of law. His attorneys either failed to do so because they made an error, or that was their calculated decision, although it seems to be an odd one. And in terms of him being there every day, this is not a criminal case where you are there, and if you don't show up in New York, we call Parkerize someone, that the case can proceed in your absence. That's not what's happening here. He can show up today or not. That's on him.
Gene, of course, Donald Trump has lost a big part of this case already, maybe the biggest part of this case. The judge made a summary judgment saying that Donald Trump and his sons did commit fraud here. As they continue on through this case to determine the other several counts, which get to the issue of intent, what will be allowed and not allowed? Yesterday, they had this whole thing with whether there's a statute of limitations on some of the accounting that took place before. How much is that going to matter going forward?
Well, I think Donald Trump got a little bit ahead of his skis. I did a ton of civil and criminal tax cases for DOJ. Even though tax returns, financial statements are outside the statute of limitations, you can use those documents as a prologue to show absence of mistake, intent, plan. So Mr. Trump was happy about some innocuous comment by the judge, but if you have returns that are, say, 7, 8 years old, but they are consistent with the returns and statements you are presenting in the charged counts, that comes in as relevant conduct. Relevant conduct.
Jeremy,
Saland.
Gene? Yeah, thank you.
You say Jeremy and I'll say Gene.
Okay, Jeremy.
Gene, thank you so much.
Thank you, Bob.